Welcome back. I'm Don Cleveland, the author of Revitalizing America. And today we're going to take up where we left off the last time, and that's we're going to talk a little bit about what happened after the revolution ended, after the surrender at Yorktown, after the failure of the Articles of Confederation. Before going into specific details of some of the failings of what happened in 1789, that's the date of the adoption of the Constitution, it's important to look at two definitions. What is a human right and what is a civil right? A civil right, by definition, happens to be the rights that are guaranteed to us as citizens of a country and residents of this country by legislation and the Constitution. You can throw in court decisions as well, because that's a form of law. In other words, a civil right does not exist unless that right is given to anyone by the Constitution or other law. Now, on the other hand, a human right is something that's inherent to all human beings, regardless of their race, their sex, their nationality, their ethnicity, language, religion, or any other status. A human right includes the right to life and liberty, to freedom from slavery and freedom from torture, to have the freedom to express your opinion and tell others what you think, the right to work and education, and many, many more rights that exist just because you are a human being and you're entitled to these rights without discrimination. So a human right exists even though there is no law or constitution describing it. It is given to every human being wherever they are found in the universe. The key then becomes to recognize the human rights in the Constitution or the statutes to make them enforceable civil rights. The preamble made a lot of promises. It made a great number of promises. It was to give us justice and liberty, a common welfare, and defense. In other words, many of our human rights were to become our civil rights and enforceable. However, the Constitution given to we the people, let's call it in its initial phase, the naked Constitution, didn't deliver. Instead, it gave us a framework of institutions that should have followed the guidance of the preamble to deliver the promises that were made on human and civil rights. The naked Constitution was lacking in normal civil and human rights. As a matter of fact, if one looks at the definition of civil right as discussed before, one of the only individual civil rights solidified in the naked Constitution was the protection of the right of slave owners by requiring the return of escaped slaves to their masters in the slave states. Even the fundamental right of habeas corpus was compromised by allowing Congress to pass laws nullifying habeas corpus in the event of a rebellion or invasion. Without the right of habeas corpus, the government can hold someone in secret without publicly being charged for their alleged crimes. This guarantee was continually bashed by the Patriot Act, despite the fact that there was no rebellion or no active invasion of the United States. Two other protections given in the naked Constitution could have an indirect impact on human and civil rights depending upon how Congress enacted laws. Congress was prohibited from enacting bills of attainder or laws that were ex post facto. Now, what's a bill of attainder and what's an ex post facto law? Well, according to the Supreme Court, a bill of attainder is a legislative act which inflicts punishment on someone without a judicial trial. An ex post facto law is a legislative act that retroactively changes the legal consequences or status of actions that were committed or relationships that existed prior to the passage of that law. A good example could be changing a law which allowed marriage at the age of 16. Imagine a new law which made the legal marriage age 18, and at the same time abolished all marriages of persons who had legally married at age 16. Among other things, the new law would destroy all of the property and child custody rights of the persons who had legally married at age 16 prior to the new law. So the Constitution prohibits bills of attainder and ex post facto laws. During the adoption of the naked Constitution in 1789, objections were raised about the lack of protection of individuals or states. Several members of Congress, apparently led by James Madison and influenced by Thomas Jefferson and Alexander Hamilton, drafted a Bill of Rights, or the first 10 amendments to the Constitution, to take care of these flaws. It's reported that these thought leaders took many of their ideas from the Virginia Declaration of Rights, which was adopted in 1776. It's interesting to note that Section 1 of the Virginia Declaration reads as follows, that all men are by nature equally free and independent and have certain inherent rights, of which, when they enter into a state of society, they cannot, by a compact, deprive or divest their posterity, namely, the enjoyment of life and liberty, and the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. These are very broad human rights issues. While this section may have greatly contributed to the wording in the preamble of the Constitution of the United States and influenced the tone of the Bill of Rights, it also demonstrated the blindness of the authors who led a government which embraced and supported slavery. So Madison, Hamilton, and Jefferson thought that the naked Constitution needed to have some civil rights clothing. Let's put something on this document so it's not just naked, but it has some civil rights protections. But it didn't happen overnight, because the Constitution laid out in the naked Constitution a very cumbersome process for amending it, and it took some time. The Constitution was adopted in 1789. It took another 2 years for the Bill of Rights, or the first 10 amendments, to be adopted, and that happened in December the 15th, 1791. Civil and human rights interests also suffered another blow when, according to the National Constitution Center, Congress turned down 5 of the amendments Madison wanted to include in the Bill of Rights. The importance of these excluded amendments is significant because they gave the people of the United States additional civil and human rights beyond those incorporated in the first 10 amendments. The deleted items that were presented by Madison included, number 1, that there be prefixed to the Constitution a declaration that all power is originally vested in and consequently derived from the people, that government is instituted and ought to be exercised for the benefit of the people, which consists in enjoyment, here we go again, of life and liberty, with the right of acquiring and using property, and generally of pursuing and obtaining happiness and safety. That the people have an indubitable, unalienable, and indefeasible right to reform or change their government whenever it be found adverse or inadequate to the purposes of its institution. This clause, which was excluded from the Bill of Rights, actually does what was promised to the people. It puts the words we were promised into words in law. It makes the promise made to us live and provides actionable protections and breathes life into the wide range of human rights by incorporating them as civil rights into our fundamental document of governance for the country. But it never made it. It became a scrap of paper on the floor of Congress. Another item that was deleted was the following: no state shall violate equal rights of conscience, or the freedom of the press, or trial by jury in criminal cases. Another scrap of paper on the floor. Another item excluded was the following: the powers delegated by this Constitution are appropriated to the departments to which they are respectively distributed, so that the legislative department shall never exercise the powers vested in the executive or judicial, nor the executive exercise the powers vested in the judicial or the legislative, nor the judicial exercise the powers vested in the legislative or executive departments. That was also a scrap of paper on the floor. We have, in the meantime, numerous quasi-judicial functions being performed by executive offices in Congress. Another one on the floor was: the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security for a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. So, we missed the civil right of being a conscientious objector. The final big difference that Madison wanted was the entire Bill of Rights interwoven into the Constitution and not just appended to the end of the document. Wikipedia has put together an excellent table showing the variations of the amendments accepted and rejected by both the House of Representatives and the Senate in the formation of the Bill of Rights. See Wikipedia's discussion of the United States Bill of Rights. Well, after the adoption of the first 10 amendments, we still had a half-naked Constitution. So we went from a naked to a half-naked Constitution. The leaders of the nation would still need to struggle to muster the political will and the strength to free the slaves, and it took a civil war to do that. They needed to make senators directly elected instead of having the states appoint them. They needed to provide civil rights protections to all persons through equal protection and due process, which has in many respects now become a joke as well.
Next week, I shall ask the Congress of the United States to act, to make a commitment it has not fully made in this century to the proposition that race has no place in American life or law. The federal judiciary has upheld that proposition in a series of forthright cases. The executive branch has adopted that proposition in the conduct of its affairs, including the employment of federal personnel, the use of federal facilities, and the sale of federally financed housing. But there are other necessary measures which only the Congress can provide, and they must be provided at this session. The old code of equity law under which we live commands for every wrong a remedy. But in too many communities, in too many parts of the country, wrongs are inflicted on Negro citizens, and there are no remedies at law. Unless the Congress acts, their only remedy is the street. I am therefore asking the Congress to enact legislation giving all Americans the right to be served in facilities which are open to the public: hotels, restaurants, theaters, retail stores, and similar establishments. This seems to me to be an elementary right. Its denial is an arbitrary indignity that no American in 1963 should have to endure, but many do.
They also needed to allow non-property owners and women the right to vote. It would require almost 200 years to get that far. It seems our founding fathers couldn't even match the Constitution of Corsica implemented in 1761, which gave all men over 25 the right to vote, and continued, note I didn't say start, and continued the right of women to vote as well. Through this whole process of explaining what happened, everyone should focus on two key points. There were many promises of human rights being turned into civil rights in both the Declaration of Independence and the preamble to the Constitution. but they weren't really turned into law. Very few, if any, were written into the Constitution. Human rights are not enforceable in the United States unless they become written into law and are made civil rights. Only civil rights can be enforced by the courts, and without enforcement, there's really no standing, is there? Learn more about our Constitution and the shortcomings in human and civil rights in my book, Revitalizing America. And for more information on the promises made and broken, you can visit my website at revitalizeamericanow.org, or better yet, you can buy a copy of the book on Revitalizing America from either my website or from Amazon.com. We'll speak again. Thank you.